I'm advocate otherwise. Today it might not reach. So it can go to the date of your choice.
Okay. 10th of December.
10th of December. 10th of December.
Lords, an order has been passed, ex parte order has been passed by the State Commission, Lords, consequent to which in the execution petition, a warrant has been issued. So, Lords, 16th is the case. So, may I request that it be posted on
Warrant
Monday?
in respect of?
Lords, it relates to the home buyers, Lords. I am the landowner. In fact, even I have been defrauded by the builder. I have terminated the tenancy, the agreement.
Warrant for what?
Lords, non-bailable warrant for arrest, my lords. The order has been passed by the State Commission, Consumer Forum, that the builder and the landowner pay the amounts sought for by the buyers, my lords, the home buyers. My humble submission is that it's an ex parte order. I have suffered. I have terminated the agreement.
$15th.
Much obliged.
In this case, my lord, the suit for ejectment.
Pardon?
Ejectment. Eviction order has been passed. They are not paying the rent. They have obtained the interim order from this court. There is an urgency, my lord.
2nd December. Pardon?
Non-payment of
December. 3rd December.
The contempt matter, my lord, there is a direction to pay the bills amounts, my lord. Despite that, my lord, no steps have been taken. But this contempt after service of notice will not has not been posted before the court, my lord. Date may be fixed. Date may be fixed, my lord.
There is no urgency.
But after service of notice, my lord, matter has not been listed.
The date must have been given.
23 matter.
Date must have been given. Which date is given?
No, date has not been given, that's why.
Not been given. Verify, if there is no date given, then post it on 5th of December.
Please.
If date is given, we will not post.
Please.
It will not change unless you file IA.
Please.
Yes, madam.
Lordship, the petitioner is in the business of sole crushing activities, your lordship. The petitioner is a license, has a valid license, your lordship. The erstwhile partners of the firm, they're trying to create the trouble and they're not, they've complained with the respondent one, your lordship, that is the mining department making false allegations, your lordship. I request your lordship to take the matter on an urgent basis, your lordship. Otherwise, the business of the petitioner will suffer, your lordship.
2nd December.
Your Lordship, a commercial appeal, Your Lordship. A commercial appeal, Your Lordship. The suit for rejection, Your Lordship. In this, the petitioner herein had running a saree shop in the premises, Your Lordship. And the respondents herein had given a notice for eviction saying that they need the premises for their son prisoners, Your Lordship. And however, the suit came to be ordered ex parte without my knowledge, Your Lordship. On the same day, I had filed an execution petition. I have gone objected there. The court didn't consider it, and now they have given an order for it. The ejectment, Your Lordship. In the same being, I have a material worth of 1.5 crore and for the security deposit of 1 crore, Your Lordship. If the same is not protected, Your Lordship, then I shall suffer, Your Lordship. And the execution has been kept to arrest on Monday, Your Lordship. The urgency.
You take time in execution.
We went and we sorted the time, Your Lordship. The trial court judge was not leaned, Your Lordship. Hence being the urgency, the only thing is, Your Lordship, at least my security deposit, and if they have given me an opportunity to remove my equipment and my material which is there in the shop, that would be appreciated, Your Lordship. If not, I shall suffer at large, Your Lordship.
15th.
Much obliged, Your Lordship.
Your lordship, one more. The contempt petition, your lordship.
Another matter.
Contempt petitioner, your lordship. The petitioner has got with respect to the defamation of the petitioner, your lordship. The lower court has made the order in favor of the petitioner, your lordship. The petitioner is a very well-reputed businessman and the ex-secretary of the Karnataka Karnataka Cricket Association, your lordship. But the respondent is not complying with the order of the civil court and he's continuing to claim the petitioner, your lordship. I request your lordship to kindly take up the matter in urgent basis, otherwise the reputation of the petitioner will be at stake.
No, reputation of petitioner will high. You are representing the petitioner. Then there is no question of.
Your lordship, but the respondent is not complying with the order of the lower court, your lordship. He's continuing to defend the.
4th December.
My lord's permission, bill number 31, it's a contempt petition. Day before yesterday, notice was, I appeared for the accused. Yesterday, I have filed the masala. My lord's, it is listed for non-filing of reply, filed reply, my lord's, for some reason.
Which one? Serial number?
31.
31. All right. When do you want? Other side is now informed.
I appear for complaint.
We'll go to December 2nd.
Serial number 14 and 16.
14 and 16.
Senior has health issues, my lord. Kindly adjourn for next week, my lord. 14 and 16. 14 and 16.
14
14 and 16.
and 16. Fourteenth.
Okay.
14. 14, 11, both.
Lordship, willful disobedience of the order of the Honorable Court. They are demolishing about 125 houses. Out of that, one of the petitioners me, and almost everybody is from Sari, ex-Air Force personnel and defense personnel. Lordship, may kindly accomplish this matter on Monday, at 11. Otherwise, they're already started demolishing. It's continuous process is going on. From yesterday, day for yesterday, for the past 1 week, they're doing it.
So it is writ appeal.
It's a contempt.
Contempt. Why they are demolition?
They are demolishing because they are trying that it is their property. And all these residents are there from almost more than 18 years.
So is there injunction, is there stay order against demolition?
Lordship, lot of people have gotten even stay orders also in the writ petitions, but that also has not been adhered to. There's a clear instruction given by the learned.
What is the breach?
Breach is that there is an order that whoever is not a participant in the Tahsildar order, they should be given a time for to hear. Without hearing, no eviction should take place. And moreover, Tahsildar has passed an order for a private layout. It's not a government property also. That is the issue also.
Doesn't appear to be. All right. 14.
Lordship, by 14, they have demolished everything, Lordship. Monday,
Doesn't appear to be genuine.
Lordship, I'll give the complete explanation. It is all genuine only.
Monday.
From 18 years, we are there. Monday, please, thank you.
Can you mention through VC, sir?
Much of that.
Contempt matters, seal number 1, Mr. Sundaresh HC.
But appear for complaint in this case. But the delay, my lord, what occasion the court has directed to file an additional affidavit. Lordship may kindly see. Para 5 of the additional affidavit.
So this is also delayed,
Yes,
barred by section 20.
Para 5, my lord,
Para?
Para 5 of the additional affidavit. So I submit that after receiving the certified copy of the order for the representation before the accused dated 26/11/20 along with the relevant documents with request to allot alternate receipt in my favor. It is further submitted due to COVID-19 pandemic, the BDA has not permitted me to visit the office to verify the consideration of my application. They have permitted me to visit the office only in the month of November 2021. Thereafter, I repeatedly approached the respondent with the request to consider my application for allotment of alternate receipt as per the order passed by the Honorable Court. I have further submitted that once one of my family member was affected with COVID-19 positive in the month of February 22. Entire family was kept under self-quarantine.
When did you made a representation? When did you made a representation? When did you made a representation?
Representation, my lord, immediately we have made a representations.
Date, give the date.
Date, your lordship may kindly. Annexure G, Annexure F, 26/11/2020.
26,
Annexure F, page 30.
26. We want only date. Date,
Date 26/11/20.
November,
November 26/11/2020. Immediately after disposal of the writ petition.
20.
Please,
20.
20.
When they did receive?
Well, they have received on same day. They
On
have
the same.
received.
Within 2 months, they were to decide,
Yes, within 2 months, they have to decide.
They
Decide.
decide.
They are not decided.
and you are waiting for 4 years.
No, because of pandemic, my lord, I have waited. Pandemic 19, my lord, I have. Then, my lord, your lords may kindly see. This court has held that, my lord, the limitation is not applicable to the contempt of the Honorable Court. And the article 22 last minute. Only a limitation, your last minute.
Which is judgment, Pallavi Shet.
This judgment, my lord, the issue has, no. Kindly see, my lord, the question of law, whether the period of limitation of 1 year for initiating proceeding for contempt of court from date on which,
What is this? Karnataka judgment? What does it say?
please, my lord. The court has held that, my lord,
Yes.
the limitation is not applicable for the contempt of this honorable court. It is under Article 215 of the Constitution. There is no limitation.
There are some judgments after this of Supreme Court. This is of 1990. You search out. One is Pallavi Shet, in which the 250, Article 215, vis-a-vis section 20 is considered.
20.
To find out, then we'll consider.
Please, my lord, notice.
Notice right
Notice
now,
may be
we are not
ordered.
inclined. To find out some other judgments of the
Yes.
Supreme Court, which might say that 1 year may not apply.
Yes.
When you will submit? 20th November.
Please.
This number 2, Arun BM.
This matter was argued,
This is same.
please, it was argued last week, and your lordship said, pass orders with regard after hearing the matter. The issue was the endorsement was
Okay. This was kept for orders?
orders.
Let it. be.
One is on,
Not given to me. 13th of December, November. इसके साथ को जजमेंट करो।
much obliged.
Number 3,
behalf of
Kavita Damodar.
petitioner. Matter has been listed day before yesterday. Survey has been conducted and the department is not
Lord,
submitting the survey report. Though they have submitted.
Report
the
has
survey
been
report-
filed with the registry, my lord. Report has been filed with the registry in the writ petition, my lord. It has been complied, my lord. Report has been filed. Earlier, my lord, survey was conducted, report was not filed in compliance with the
Now it is
interim
filed.
order. It has been complied. I'll share a copy of the documents filed in the writ petition, my lord. For his case.
Nothing survives. If this is done, then nothing survives in the contempt petition.
Learned additional government advisor, Mr. Harish, stated that the survey report,
Survey was done, my lord. It is not in dispute, my lord. Only report was not filed. That
Survey
was
report.
been done.
has now been filed, copy of which is given to learned senior advocate for the complainant, Mr. So-and-so. So-and-so. He was not in position to dispute the factum of filing of survey report. The revenue of the above developments, nothing survives in the present contempt petition. It is accordingly disposed of.
Grateful.
Number 4, Uday Kumar RL.
Complainants are the legal heirs of the late Nagaraju. Late Nagaraju is the retired employee of the accused bank, my lord. When he was retired, his retirement benefits were deducted to the extent of 1,85,000. That was challenged by referring the writ petition. This honorable court allowed the writ petition, page 15, my lord, para 14. The sum of rupees 1,75,700 plus 10,000 that has been recovered from the petitioner shall be refunded to the wife of the petitioner forthwith. That is the first complaint, my lord.
Notice, 2nd December.
Number 5, Sanjay Kumar, Snake party in person.
My lord. This honorable court passed the order on 23rd November 2023. And this, our office, they not accepted that order and they didn't issue this complaint order. So I filed the contempt of the court. So in this petition, they mentioned that reply in
Whenever.
FR 27.
2nd December.
In FR 27, they initially said this, they cannot.
We issued notice.
Yes, sir?
We issued notice. We issued notice.
Okay.
Mr. Rajeshwar PN.
Hearing for the complainant, my lord. The complainant was a deputy manager at the respondent's corporation, my lord. There was an order of dismissal that there was a misconduct. Against that order of dismissal, a complainant had filed an appeal, and even before the appellate authority, even the appeal was dismissed, my lord. Against that order of dismissal, the petitioner had filed a writ petition before this honorable court in the year 2010, my lord. This honorable court from the
Learned
In the-
single judge, while allowing the petition of the complainant as per his judgment and order dated 25th September 2023, set aside the order of dismissal passed against the petitioner plus complainant who had retired. Full stop. Paragraph. While the question of reinstatement would not arise, further direction issued by learned single judge. 25% of, 25% back wages to the petitioner, in addition to the other terminal benefits. Full stop. It is in respect of the above directions that the contempt of court is alleged by the petitioner by filing this contempt petition. From the directions as above contained in paragraph 41, 42, and 43, it could be seen that even though the payment of 25% back wages is directed, no time limit is fixed by the single judge. Correct. No time limit is fixed. Not possible to come to conclusion at this stage that any of the respondents have committed contempt report from a much less any willful contempt. Then directions of the court should not go uncomplied with. That view, it is directly and shall carry out the direction of payment of 25% back wages to the petitioner as contained in paragraph 43 of the aforesaid judgment and order of law and single judge within 10 weeks from today, failing with 8 weeks from today, failing which the respondent authority shall be exposed to contempt proceedings. This petition is disposed of accordingly.
Number 7.
Yes,
Mr.
appear for the
Nagaraj asks-
complaint, my lords. In this case, there was a direction of this honorable court to consider the representation of the petitioners here in.
What is the direction?
Including the operative portion is at page 32, my lord. The land, it pertains to denotification of lands which were acquired. There was a direction by this honorable court to consider the representation within 3 months.
It is a final order?
Final order, my lord. Page 32 is the operative portion.
Take notice, my lord. BDA has to consider the
Notice returnable
representation.
on
Notice to BDA as well.
2nd December. Learned advocate, additional government advocate, Mr. Harish accepts notice on behalf of state.
BDA.
The rest of the respondents will be solved. Next.
It's arbitration miscellaneous first appeal, seal number 8. Tanuk,
This is yesterday's. So it is perfectly in order. Yes,
I appear for the.
Lord, I am
appellant
for
in
the
this matter.
respondent number 1, my lord.
correct. Yes,
I appear for the appellant in
the
this matter.
29 days delay.
Please, my lords, 27 days.
My lord, the cost given by them is not sufficient cost, my lord. They are telling that they don't know the jurisdiction of the court.
Pardon?
They said that, they are saying that they have a confusion regarding the jurisdiction of the court in which this application has to be filed. They have a team of legal officers employed with them, my lord. And day in and day out, they appear before this trial.
So and so for the appellant and learned, we are on caveat. And learned advocate, Mr. So and so for the respondent. Full stop. The appeal is admitted, it shall be listed for final hearing at 2:30 on 20 November.
Let's have sought for a stay, my lords.
So there shall be no
Stay to-
further proceedings in relation to the subject matter involved. In view of that, the present
lord,
appeal is pending before this.
One
court.
submission, my lord, they have not deposited the.
Both
What
I
about
think
the-
today, he is facing some execution, then we will grant stay.
this for withdrawal. seal
On
number-
21st, Mr. 20th will take up the final hearing. It's a short matter, right?
This for withdrawal, seal number 9. Mr. Gnanesh Kumar K.
Appearing for the state, my lord. Respondent.
Yes,
Number 9, Mr. Gnanesh Kumar.
nobody is there. 3rd December.
It's for withdrawal of the contempt, my lord.
Memo.
Withdrawal of the contempt.
Figures on record. Memo dated 1/10/24. Whereby learned advocate complainant. Great permission to withdraw the petition. Has not pressed. In view of the memo, dismissed has not passed.
Seal number 10.
For the complainants, my lords. On previous occasion, my lords, it was heard, my lords, and I submitted before my lords that there is no compliance, my lords, from the respondent's end. My lords asked me to submit, my lords, and clarify on the same. If at all my laws may kindly permit me to draw my law's attention, writ court order, my laws. My laws may kindly see, my laws, it is at page number 18. My laws, writ court, my laws, has directed the respondents, my laws, to complete the process of land acquisition and pay compensation in respect of 155 square meters of land which was acquired and notified, my laws, in 2021. Now, my laws, the respondents have filed an affidavit saying that, my laws, there is an overlap of mentioning the land acquisition and they have not indeed acquired 155 square meters of land. And they have written a letter, my laws, to denotify it. That, my laws, may kindly see, as per their own affidavit, my laws, that letter is written, my laws, after 4 years, and that too after filing of the contempt petition. All these contentious, my laws, raised before the writ court. And, my laws, after that, my laws, the council made a submission, my laws, that they will process for 155 square meters of land. Considering that, my laws, the order has been passed. Now, my laws, contrary to their own submissions, my laws, they are taking contentious, my laws, that they are not obligated to pay. One. Second, my laws, may kindly see their contentious, my laws. They are saying, my laws, whatever the compensation they were ought to have paid to the petitioner, negligently they paid it to adjoining landowner in 2015 with regard to 51 square meters of land. And now, my laws, they are paying the compensation, my laws, what they were supposed to pay in 2015, my laws, without including the interest component. If at all, I may draw my law's attention to the interest, their calculation sheet, my laws, what they have submitted before my laws in their statement of objections at page number 56.
This is that matter.
Same matter day before, my lord, and I didn't want to comment. Unfortunately, my learned friend doesn't show up at 2:30 when your lordship specifically says 2:30.
My laws,
That day he restricted his submission to interest. Now he wants to re-argue the matter. I didn't want to
no,
interrupt.
my
but this
my
is not
apologies,
right.
my laws. In fact, my laws, yesterday I checked the order sheet, my laws. It was not listed in the order sheet. I was genuinely thought, my laws, that it is not listed. I checked it, my laws, it is shown as 80 on today. So, my laws, I appeared on today, my laws.
Kept at
My
2.
sincere apologies, my laws.
We don't want apology. It was kept at 2:30.
Yes, my lord. But it was
Then-
not in the call list, my laws. Then I thought there is
Where is
some.
the cause list? On the same day it was.
Same day, same day.
Morning, up to 1:30, then it's.
Correct. And your lordship said.
Don't
come
play
back at
excuse.
2:30.
If you want time, straightway ask for time. Excuses are not tolerable.
My laws, my sincere, it is wrong on my part, my laws. I thought, my laws, it is adjourned to next date, my laws. I sincerely, my laws,
Anyway.
it's my mistake,
Anyway,
my laws.
Yes, proceed.
I sincerely apologize, my lord.
Forget that.
Please, my lord.
Proceed.
Please. My laws, may kindly see, my laws, page number 56, my laws, of their
Of their
statement of objections,
Yeah.
my laws, what they have filed.
page 57 or 56, page even. What is this?
There, my laws, may kindly see the date of notification, what they have mentioned at page number 56. Date of notification under section 28(1), 17/10/2015. Then, my laws, they have mentioned the land cost and the 100% solatium, but they have not added interest component to that, my laws. So they have acquired the land, my laws, in 2015. And, my laws, they are paying me compensation in 2024, my laws, without adding interest to that amount. The writ court, my laws, has directed them to pay compensation in accordance with law, my laws. When it means, if at all I may submit, my laws, the citations, my laws, wherein the Supreme Court, my laws, were categorically describing the state duties under Article 300 of the Constitution of India, my laws, has categorically said, my laws, the state has to pay compensation first and then it has to acquire land. And if at all it fails to do so, then the interest must be paid, my laws. In this case, my laws may kindly see, my land was acquired, my laws, compensation was not paid. It was paid to some adjoining landowner. Then, my laws, they notify, my laws, additional extent of land, because of which, my laws, I am not able to use that additional extent. That is 155 square meters of prime land in Bangalore, my laws, I am not able to use it from 2021. Now they are saying, my laws, they have written a letter, my laws, to denotify it. My laws, unless it is denotified, my laws, that land is not useful to me at all. I cannot use it. They have to substantiate or at least submit a timeline, my laws, within which it will be denotified. They have neither paid me compensation, nor they have issued the denotification or allowed me to utilize my own land from 2015, my lords. In their affidavit, my lords, they are saying that 8.5 meters of land, they have not utilized it, and that's why they will return it to the petitioner now. But however, my lords, they have not mentioned which side of the portion of the 8.5 meters have not been used. The land, my lords, is in their possession since 2015. After 9 years, they are coming before my laws and saying that they have not utilized the land and they will return it and I should accept the same. Without knowing, my laws, the location of the land, whether it is useful to me or not, I am not even aware about that. They have not even filed the map, my laws, describing which is that 8.5 square meters of land which they want to return to me.
So you are supposed to pay the compensations for 129.5 meters.
Of which 78 admittedly is already paid way back in 2018. For the balance 51.05 square meters, they've already deposited that amount of about 1.36 crores with the Karnataka Industrial Area Development Board, and they are at liberty to withdraw that amount. Now, if they are aggrieved by the quantum of compensation,
How did you
liberty may be reserved to.
Quantum years, but then all interest, solatium,
Solatium is given, 100% solatium is given. If my lord were to see page 56, there is 100% solatium.
interest,
And it's a package compensation.
interest compensation, package compensation.
Package compensation.
Agreed amount, agreed amount.
Oh, it's an agreed
Consent
amount.
award.
Yes.
Consent award.
Yes.
My laws, it was, my laws, dated 2015. My laws, it was supposed to pay paid my laws within 12 months. They have not done it. They are paying that amount my laws in 2024. That is after 9 years, my lord. And they are not ready to pay compensation. All their contention is, my lord, they inadvertently paid it to somebody else. That is their contention. They acquired my land, my lord. They did not pay compensation for 9 years.
So you are claiming interest.
My lord, interest also has to be paid. Interest also has to be paid on that, my lords. Apart from that, my lords, 155 square meters,
So
they
you are
have
not,
to submit, my lords, as to when they will denotify, my
you
lords.
are not satisfied with the amount of compensation because of non-payment of interest.
Not only that, my lords, I am dissatisfied, my lords, because it is not in compliance with the writ order, my lords. Writ order clearly says, my lords, it has to be paid in accordance with law. And, my lords, Supreme Court has established, my lords, that the law is that they have to pay interest, my lords, if at all there is a delay. If at all they are not mentioning, my lords, what is the interest they are going to pay in the amount, my lords, cannot be a compliance. One, my lords. Second, my lords, unless and until that 155 square meters of land, my lords, is denotified. My lords, may kindly see it is useless to me, my lords. I cannot even use it. They are saying, my lords, they have written a letter. Writing a letter will not absolve them of the responsibility, my lords. Unless that is denotified, my lords, how can I use that land? After 4 years, they are coming before my lords. After
Excess land is not denotified.
No, it's not that much. This is why I would try and draw a distinction. In regular circumstances, certainly interest would possibly follow any amount. You must kindly see the conduct of the petitioner here. He was well aware of the fact that this land was already notified. Now, after in 2021, when we conduct a resurvey, that is when we find out that this land has been notified twice over, and for which a partial compensation was already given. Yes, admittedly, part of it was given to the wrong person. But what my lords may ask yourselves is this. Now, the petitioner approaches this honorable court for 155, knowing fully well 155 is notified twice over. And now, my lords, he backtracks and says, give me interest. Now, given the conduct, it was basically a chance saying that, yes, the same land is notified twice. It's not as if that land he was deprived of it. The land was already notified, land was already possession was taken. Now, by mistake, that 155 was notified all over again, which is why, my lords, yes, and rightfully so, he sought compensation twice over. But now, my lords, we've realized our mistake and said, not denotification, please delete that 155 square meters, because it's already been notified, already a subject matter of acquisition, for which compensation is given. Now, of course, there's that small portion which we had to reallocate. To that extent, my lords, maybe reserve liberty to seek his remedies in accordance with law if he seeks any enhancement.
That portion which you are going to, you have to pay
Yes, my lord.
for the rest of the
Correct.
land. That portion of amount has to be coupled with interest or not?
I would respectfully submit, my lord, in the facts of this case, given the conduct of the petitioner, it may not be, balancing the equities.
Conduct will hardly relevant.
I'm sorry, my lord.
Conduct is not relevant. In
May
that-
not be, my lords, but of course, then my lords, may I submit this? The petitioner will be reserved liberty to work his remedies. If he seeks interest, he may have to initiate appropriate proceedings. I will then be at least be able to defend myself in those proceedings as to whether interest is payable or not.
Why it is not?
Well, I'll explain.
It will statutorily follow. Payment of interest.
Well, it's a package compensation is what I'm instructed to submit. It was agreed upon that this is the amount that was payable. Now, 100% solatium is also been included. If my lord were to see page 56, the amount is about 63 lakhs, 100% solatium, another 63 lakhs, plus about 8 lakhs, so and so for the some 12% additional market value. That works out to 1 crore 36. And what was submitted before the learned single judge was, given the fact that there was already a notification for 155, we had submitted that we will take it to its logical end. That's when we found out that that land has already been notified, compensation paid. That's when we found out that, of course, some amount had to be reapportioned. And in fact, the first reapportionment happened, Malats, in 2018 itself. When Bindu Raheja was paid, I think the amount is, Malats, if Malats were to see page 58, 2 crore 24. 2 crore 24 was taken back from Bindu Raheja and paid to him in 2018, 29th August.
You just file a further reply summarizing this.
Very good.
So my apologies, my lord.
Understanding that why you are not inclined to pay the interest. Put your contention in black and white.
We will.
Because doesn't look acceptable prima facie.
Very
What
good.
you
We
have
will file.
My lord, one humble submission, my lord. One humble submission, my lord. My lord, I respectfully submit, my lord, the learned senior counsel has not been briefed properly, because the learned senior counsel, my lord, is pointing at me saying that I am claiming it again and again, even though being aware. My lord, even after the notification, my lord, the respondents have written letter to me asking me to calculate as per the 2019 guidelines and ask what is the amount to be paid. My lord, I may be permitted to submit those letters also, my lord. So it is wrong on part of the respondents, my lord, to point a finger at me now, my lord.
Yeah, what is that?
My lord, they have issued a letter, my lord, after the notification saying that, my lord, my lord, may kindly see on 29/20/21 at page number 6, my lord, a letter was written from Narayan Swami to Tashildar, my lord. Before that, my lord, at page number 5, 13 September 2021, my lord. BMRCL has written a letter, my lord, to me. My lord, it is Kannada, my lord, my apologies, I couldn't translate it, my lord. My lord, asking me to submit, my lord, the compensation amount as per the recent guidelines. Accordingly, my lord, I submitted the same, my lord. In 2021, my lord, 3.65 lakhs was supposed to be paid. I submitted, my lord. They have only returned to me. My lord, they have notified my lord, my land, my lord, twice. I am not being aware, my lord. They have never demarcated it, my lord, and told me this is the extent of land we have acquired. They have notified it twice, my lord. I am under the impression, my lord, that my land has been acquired, my lord. Additional extent of 155 square meters is also acquired. Now, my lord, they are saying that it is not used. Agreed, my lord. Unless and until that is denotified, my lord, or corrigendum is issued, my lord, I cannot use my own land, my lord. They have deprived me of using my own land for 3 years, my lord.
Learned advocate of the complainant files memo producing certain documents. The same is taken on record. Respondents are directed to respond to the submissions based on the documents produced today, as well as the case of the, as well as in respect of the case of the petitioner, that the petitioner is entitled to interest in accordance with law for the compensation payable for the remaining parcel of the land. Thus reply may be filed 2nd December.
Please.
Second December.
Possession is taken when?
Position.
2016 or 17.
16.
Quite some time. Ever thrown in possession?
The possession was taken, my lords, initially, my lords, there are two survey numbers, my lords, 43/2 and 44/2. And certain portions in both the lands were acquired. Initial notification, my lords, was on 26/11/2016, my lords. And it was acquired. Second notification, my lords, was in 2021.
Let it be on 25th of November.
Please,
It would be 26, not 20.
26.
Likely have to go to Harvard.
26th.
please. My lords, my sincere apologies, my lords. I was under the impression that it is adjourned.
You forgot it.
My grateful.
26th.
This is number 11. Mr. Ajit Kalyan.
I seek for a week time, my lords. I am the proxy counsel, my lords. The counsel on record had some personal inconvenience, my lords. The counsel on record, my lords, had some personal inconvenience.
What is this contempt, madam?
My lord, there was a direction, my lord. To the respondent number 1, there was a direction, my lord. There was an account of the complainant was frozen. Thereafter, an order was passed by the magistrate for defreezing the account. A writ petition came to be filed for direction to the respondent police to instruct the bank to defreeze the accounts, my lord. That several mails we have produced along with complaints affidavit, my lord.
He wants time, let it.
Very well.
2nd December.
Bill number 12. LS Venkata Krishna.
We have complied. Please.
Both the learned roads are addendum that the order under contempt is complied with. Any of this joint statement disposed of as not survived.
Bill number 13. Mr. Muralidhar HM.
For the complaint, my lords. This is a matter regarding the employment in a bank, my lords. The complainant was working in the accused bank in the year 1990 as a loan recovery agent, my lords. In 1993, the bank had removed the complainant from working, my lords. So he had raised a dispute before the Joint Cooperative Society under Section 70. The Cooperative Society dismissed the application filed by the complainant and stated that the complainant may be taken as daily wage worker on the discretion of the bank. So he had made an appeal before the KAT in appeal number 605 of 2008 before the Karnataka Appellate Tribunal, my lords. The KAT had allowed the application and directed to reinstate the worker. So the bank had filed a writ petition challenging the order passed by the KAT, my lords. In writ petition number 35377 of 2018, my lords. After talks of settlement between the parties, they arrived at a settlement in 1/2/2021. So as per the settlement, the terms and condition of the settlement was that the respondent is the complainant in that case, my lords. So the respondent agreed that he has been reinstated in the service with effect from 18/8/2015 as a regular employee and that the respondent is continuing in the service.
So there is no direction, only settlement is recorded.
Yes, my lords.
No
No
contempt would lie.
Here, my lords, they have reinstated the complainant as a regular employee from 2015, my lords. From 2015 to till the date of the retirement, they have not properly paid the salary to the employee, my lords. They have paid only the salary which is being paid to him at the grade of his employment when he was a loan recovery agent, my lord. They have not paid him salary according to the 2nd division clerk, my lord.
5th December. Notice. Objection, sir.
They have also filed the objection, my lords. Even they have received the notice and filed the objection, my lord.
Who is paid?
Their contention is that they have paid 4 lakhs. That 4 lakhs is paid according to the KIT's order, my lords. They have not paid the salary properly, my lords.
Mr. Krishna R.
Nineteenth. Nobody is here. Yes.
14 urgent, seal number 15, it's a green bench matter, the Prakash M. Patil.
But I have challenged the annexure A and B. My lord, notice issued by the respondent. My lord, directing the, my lord, the petitioner to pay royalty of, my lord, 2 crores. Kindly see, my lord, page number 39.
It's written on 2nd December.
This is seal number 17. Mr. Aditya Narayan.
This matter, I appear for the petitioner. Lords, Mr. Holla is leading me in the matter. Learned Senior Counsel, Mr. Holla is leading me in the matter. He appears to be on his legs, my lords, but your lordships kindly pass it over.
My lord, in this matter, it was stated that, my lord, it was covered by
Covered.
a decision.
It's covered, my lords.
My lord, it's not covered.
Lords,
My lord,
check.
we'll file synopsis, my lord, bringing to my lord's notice as to how it is not covered. My
Lords,
lord may
kindly
have
pass
to-
it over, my lords. There's some urgency, my lords, because they're putting us to a payment obligation every quarter of 8 crores.
Also,
Kind, please, my lords. I'm
Obli-
obliged.
Obliged.
This is seal number 18. It's a ready notice matters, Mr. Deepak DC.
Here for the petitioner, my lords.
what is it about?
Pertaining to the environment compensation matter, your lordship. In this case, however, there's a slight change of fact. In this case, show cause notice has been issued. They have given their reply. On basis of their reply, a revised demand notice has been issued. So the,
Same,
yes,
same order.
yes, your lordship, but here the show cause notice is already issued.
But again, they have replied.
My
again
lords,
he will
in
give.
this, my lords, a closure order was issued, my lords. A closure order was issued, then later an inspection was
Copy
made.
to your friend too of that order,
Please, your lordship.
Monday.
Please.
In a slight change of fact, in this, the show cause notice was issued and the reply has been given by the petitioner.
You give copy of the order so that
Yes,
council can know. At 2:30.
please, your lordship.
Seal number 19. It's a writ appeal matters, to Shekhar L. Seal number 19.
Or it will go to 7th December, 9th December.
Seal number 20. Vinay Kirti M.
Appear for the appellant. Your lordship, the appellant is a elected member of a town panchayat, ward number 9, Jigalur, your lordship. He was elected under the backward class B category. Subsequently, my lord, even the calendar of events, my lord, have been published. The electoral process, my lord, has already begun. And hence this appeal may not survive for my.
No, your lordship, once because I was elected for the period of 19 to 25. So 7 months, for now 7 months, they issued the fresh calendar of events.
Your Lordship, because they are not preferred any election petition challenging my election. My submission that Your Lordship, see the very act for which they question my CAT certificate is not applicable to in my CAT certificate, since my CAT certificate is not issued under the said provision of the said act.
Notice is issued, letter that the formal notice, notice written about. 2nd December, loan advocate means loan reasonable and loan advocate, name case of. Accepts notice only of respective respondents. Next.
Bill number 21. Deepak Shetty.
This objection is, we have made a register as a party. Rajiv Gandhi University is represented by a registrar. In the writ petition, my lord, they made as a vice chancellor as a party. As per the statute, my lord, be sued or be sued against the university is through registrar only. Therefore, we made a register as a party and filed the appeal, my lord. That is the only objection.
But this was mentioned and court has indicated that it is to be corrected. We ourselves stated that it is a typographical error. Registrar is to represent the university. But matter is being adjourned from time to time for no reason. We have filed a contempt, my lords, where we pointed out that the UGC having given us the status of autonomous status, the university is merely required to issue a notification. That is being not issued, my lords, frustrating the entire term. The academic year is for 1 year. If they, on this ground that it is being, this is the third time, my lords, the matter is coming before the court insofar as university's appeal is concerned.
Office objection may be overruled, my lord. Meanwhile, my lord,
It was so done last time itself now.
Office objection may be overruled and posted for admissions, my lord. See, we have engaged the service of the senior counsel troubling now.
We engaged,
Senior counsel,
which
engaged service troubling now. Last time he has appeared, my lord. Due to my ill health, my lord, I am not able to brief.
2nd December. 2nd December.
Would your lordships consider giving a shorter date? Let's the
Shorter
entire
20
writ is being frustrated.
25th November.
This commercial appeals, it's number 22.
Regular office objection.
Seek for a short pass or minutes.
22 is not office.
Seek for a short pass or minute.
What is it?
But matter pertains to the appeal preferred ordered by the commercial court, my lords. The petition was filed under section 31 and 32 of the State Financial Corporation Act.
So notice 17 December.
But the delay may be condoned, my lord. Delays of only 2 days, my lords.
On that day, we'll see. Next.
Bill number 23. Mr. Ranjan Kumar K.
Lord, appellant's section 9 petition, my lord, has been rejected. Against that, my lord, this appeal is filed. Now, the contention, my lord, is that the respondents, my lord, the owner of.
Same. Not same, not a, they give date 26th of November.
26th of November. Yes. Complaints in contempt matters, bill number 24. Manjunath BS. Accused.
Lord, firstly, I'm in deep recognition of the valuable time this court has given to this case, my lord. The matter is pertaining to land granting to the ex-servicemen.
Lordship,
Land to the. sorry,
ex-servicemen.
Yes, ex-servicemen.
So we have.
After the last date of order, my lord,
You pass some order.
My lord,
Yes.
they have granted site, my lord. My lord may kindly peruse the compliance order, what they have filed in
We have filed our affidavit on
2410, my lord.
24th of October 2024, my lord. The Deputy Commissioner Chikmagalur is also present online, my lord. After your lordship's direction, my lord, to consider the complainant's application filed in the year 2000, a site has now been allotted 60 by 40, my lord. Nearly 84 ex-servicemen can be allotted sites, and the layout is being formed, my lord. And the site has been allotted in compliance with sub-rule 8 of Rule 8 of the Land Grant 1969, which has been amended and said that if no lands are available, then sites can be allotted, my lord. And as per your lordship's direction, my lord, 2000 application filed.
My lord, I have perused this land, my lord. This survey number 201 is a 2000 acre Gomala land. There is no site that has been made in this land, my lord. May kindly see their compliance, my lord, page 19, with reference to circular dated 24/6/2021. This is exclusively pertaining to this contempt, my lord. There is no mention as to why the land which I have asked for, the said land, why there is no non-availability of that land, my lord. And also, and plus this site, my lord, like I said, there is no site layout sanction plan or anything that is which to support this layout has been provided by them, my lord.
Insofar as the development of the layout is concerned, my lord, in fact, the Deputy Commissioner is also present, my lord, online. The 10 acres is going to be developed into the layout in less than 4 months, my lord. Less than 4 months. 60 by 40 site has been allotted, an order has been passed already, my lord. I have enclosed.
May I submit, my lord? My lord, this order what they have passed, it pertains to, had I asked for an agricultural land, I have asked for a plantation crop land. The order what they have passed comes with a rider saying I have to provide my income certificate. That rule applies only when I'm asking for an agricultural land. Here I'm asking for a plantation land. My lord, it is the same accused, my lord, who has passed an order saying that the land is available and it is exclusively reserved for ex-servicemen. Now, referring to the same circular dated 24/6/2021, the accused has passed this order saying the land is not available. But there is no mention of survey number 218, which is exclusively reserved for ex-servicemen.
Let me apply the mind. 15th. 15.
Lord, one other submission, Lord.
My lord, maybe 19th.
19th November. 19th November.
Take up at 2:30.
2:30, my lord.
Much obliged.
So the site is also worth about 25-30 lakhs. There are nearly about 171 applications.
Now, what is your grievance now, madam?
My lord, I have asked for a plantation land, my lord. And I've also produced document which shows that this land is available for, is exclusively reserved for ex-servicemen.
the contention of the accused is that since there are 171 applicants, all have to be given 4 acres, 38 guntas. There is no rule, law in either in enactment or in judicial remedy, which says that all applicants have to be given the same extent of land. It is in their own document. If they peruse, they can see that each applicant, some have asked for 2 acres, some have asked for 5 acres. There is no rule. This is the defense that the accused is taking. And in that reason, they have, my lord, if they see the documents produced, they have rejected my year 2000 proposal, which they have not informed me. They are blaming, the DC blames the Tahsildar, saying Tahsildar has not informed me. Now they have passed an order specifically with respect to survey number 218, whereas there is no mention of the non-availability of this land.
Lord, in the affidavit now filed, even in the previous affidavit, we have stated what is available is only 12 acres, 38 guntas of land for purpose of providing it to the ex-servicemen. Now, what we have done as per sub-rule 8, Lord, rule 8, it provides for allotment of sites in the event of the land not being available. In accordance with that statute, my lord, we have now allotted the land to them. Its layout is going to be formed in less than 4 months, my lord. The deputy commissioner can also confirm and give that undertaking to the court if need be, my lord. The site is worth nearly about 84 ex-servicemen will now benefit, my lord, because land is not available at all.
But my lord, it is in their own, it is the same DC who has signed this order, RTI order, which says that this extent of 4 acre, 38 guntas is exclusively reserved for ex-servicemen.
Where is that? Which?
My lord, it's in page number 13 of my rejoinder dated 7/11/2024.
7/11.
Yes, my lord.
Page?
Page 13, translated copy of page 11 and 12. Reservation of land under section 71 of the Karnataka Land Revenue Act, Chikmagalur Taluk, Vastare Hobli, Chandangondanhalli, survey number 218, measuring 4 acre, 38 gundas of the land for purpose of allotment of land to servicemen, ex-servicemen reserving land under section 71 of the Karnataka Land Revenue Act. My lord, if you may kindly turn to
So
page.
this land is available.
Yes, my lord, this land is available. This document is signed by DC, the same accused, my lord. It says, may turn to page 15. In pursuance of the materials mentioned herein above, as the land is free for disposal in all manner as hereunder for the allotment of the land to servicemen, ex-servicemen, subject to conditions mentioned herein under, under section 71 of the Land Revenue Act, is reserved as and ordered. Chikmagalur, Vastare, Channagondanhalli, survey number 218, extension is 4 acre, 38 guntas for the purpose of allotment of land to servicemen and ex-servicemen.
No, this has to be read with rule 3, my lord, of the land grant rules. Karnataka Land Grant Rules, 1969. Rule 3 is preparation and publication of list of lands available for disposal. And then Lordship will also see reservation under Rule 5.
Rule 5.
The first Rule 3, my lord.
My lord, under Rule 5, first person is ex-servicemen and soldiers. So I am very much under this rule. I am eligible for this land, my lord.
Your status, they are not questioning. Your status as ex-serviceman, they are not questioning.
No, my lord.
No,
They are not disputing.
In
They are saying
terms,
that there is no land available.
Yes.
But my lord, this order was passed in the beginning of this year saying that this land is.
Clearly because of this order that this is earmarked. Is it available? This land is available?
No, my lord, now, though this land is available, your lordship will see under Rule 5, my lord, we have said on our affidavit, on our affidavit, we have said what is the total extent of land that's available for ex-servicemen. Now, the total land that is available, if lordship sees under Rule 5, my lord, we'll have to reserve it for, first comes ex-servicemen and soldiers, which is 10% of the total land which is available.
So in order of seniority,
My lord,
in order of seniority
In,
of application.
yes,
So that is she is senior. Or the
Sorry?
petitioner is senior.
no, my lord, now the,
In terms of making application. Isn't it?
it is reserved for,
No, your application is,
considered and the site has been allotted.
but not in terms of seniority.
No, my lord. Now we have considered, my lord, after your lordship's order on the last date, my lord, where we had taken a stand that we cannot allot this land, and the application of the year 2000 was not taken into consideration. After your lordship's order, we have taken that application into consideration. We have applied sub-rule 8 of Rule 8, my lord, which is amended, which says that if no land is available, other ex-servicemen will also have.
my lord, my lord, sub-rule 8, clause 8 says further that if the land is not available for grant in the native taluk as per service register, then application shall be transferred by the respective tahsildar to the tahsildar of adjacent taluks. It does not mention giving sites.
Sub-rule
It
8 of
indeed-
Rule 8 may be seen.
Rule 8, you're reading Rule 8.
Yes, my lord.
Amendment of the year 21, man. The proviso, my lord, if I'm permitted to read. Sub-rule 8 of Rule 8. my lord. Provided also that when a government land is available to be granted to soldiers and ex-servicemen, as per the list prepared and notified every year, under Rule 3, a site measuring 2,400 square feet in rural area or a site measuring 1,200 square feet in urban area shall be allotted in his or her native taluk, and if not available in the native taluk, then in any other taluk of the concerned district at free of cost under any existing housing scheme of the state government or a special scheme that the state government may form. May I pass on this, Lord? Amendment. May I pass on the amendment notification? It's not there in the statute. My lord, now by virtue of this, my lord, nearly out of 171 application in the layout that is now being developed, nearly 84 ex-servicemen would get the allotment. We have allotted, an order has been passed, and that's nearly worth about 25 to 30 lakhs. my lord. And in addition to that, The complainant had already inherited about 9 acres, 34 guntas of land.
My lord, that land has been sold. It is currently not in my name, my lord. My lord, this stage arrives only when the land which I have applied for is not available, my lord.
So then how do we establish from the record that the land is available?
My lord, it is their own response from the same DC accused who has passed this order saying that said land is free from all encumbrances and it is exclusively reserved for the ex-servicemen.
She appears to be right.
Lord, may I
At every stage, he appears to be right.
My Lord, may I make one request, Lord? May I make one request? Lordship, may kindly see the writ petition itself was filed, saying my representation of the year 2023 must be
Well, Monday,
considered.
at least I am not able to come to any conclusion. So
Yes.
Monday will-
But, all right.
Tuesday will take.
Tuesday.
Tuesday.
My Lord, Tuesday, I'm out of town. My Lord. May I request for any other date?
Wednesday?
20th.
Wed-
Much.
Not Wednesday.
Yes.
Wednesday, 2:30.
Much.
Still number 25.
For the complainant, my
TK.
lord.
For the accused in this case, my lord.
My lord, annexure A at page number 27 is the order of the single judge. Relevant portion at page number 32. Page number 32, my lord. My lords, this is a matter where the complainant is a plaintiff who has filed a suit for mandatory injunction against the accused defendant. The facts of the matter is this, my lord. The complainant is an international journalist and she has her web magazine running on the internet, for which she has hired the services of the defendant to run and maintain her web magazine. Somewhere in the year 2021, as the web magazine came to be completely shut down, the complainant was forced to file a suit in the lower court, in which on 13/12/2021, an interim order was passed, my lord, directing the defendant. That order may be found at Annexure B, page number 34. Gist of the order is that defendant was directed to host my website. Thereafter, my lords, during the course of the trial, the defendant filed an application for appointment of a court commissioner, which came to be allowed, and I challenged that order before the learned single judge. The learned single judge, while allowing the appointment of the commissioner, however, upheld the finding which was given in the interim order before the trial court, stating that the defendant is directed to abide by the order passed on 13/12/2021. However, my lord, till this date, that order has not been complied with, as can be seen that my website is still not up and running on the internet. For this, my lord, the accused has filed an affidavit wherein he admits that there is non-compliance and giving reasons as to why there is non-compliance.
The commissioner was to be appointed for what purpose?
My lord,
Commissioner,
my lord, what happened? I would like to explain a little bit more, my lord. Before we go to the commissioner, there's a little bit of background which needs to be explained. If my learned friend is finished, I would like to talk, my lord. My lord, in this case, I filed an application for appointment of commissioner. In the appointment of commissioner, I sought for several things. My lord, there is a counterclaim that I have filed. My lord, what happened was in 2021, there were certain invoices pending, which the complainant had to pay the accused in this case. That's number one. The contention of the complainant back then was that we were not upgrading the operating system from Ubuntu 14 to Ubuntu 20. because of the pressure, continuous pressure put by the complainant, it was, the website was transferred from the complainant's account to our account for just so that we can upgrade and the website continues to run. Now, what happened was within 10 minutes after I transferred the website, the complainant changed the password and prevented me to have access to the website. That is one. Subsequently, we have made several submissions to her. Sorry.
Commissioner is appointed or not?
Commissioner was appointed. He gave an initial report, which was totally one-sided, which is already marked, which is submitted by the complainant herself. Not, but I would like to take you to page number 127.
You are the petitioner.
I'm the plaintiff,
No, no,
petitioner. In the High Court, I'm the petitioner.
and also the plaintiff.
Yes, please, ma'am.
But she was,
If the commissioner is appointed for carrying out the directions in the order dated 13/12/22, then it ends,
yes, my lord.
end of the matter.
Yes, my lord. The problem here is, my lord, page number 127. Page number 127. My lord, this order on 13/12/2022, it was passed. It says, my lord, at page 67.
Now you show from the record that the commissioner is appointed.
My lord, yes, my lord, the commissioner is appointed, but the,
Any order?
sorry,
Any order of the trial court?
my lord, commissioner is appointed at page 105.
Page number
Page
108
105.
at Annexure G, my lords.
My lord, the writ petition was filed challenging the appointment of commissioner in the first place. The writ petition which the complainant is saying that I'm not complying the order with, that writ petition was filed only to challenge the appointment of the commissioner.
We are not concerned. We are concerned on the direction number 2 at page 32. If the commissioner is appointed by the trial court,
Yes, my lord.
then things will not travel further.
My lord, I agree. My lord, on 26/10/2024, 1 week ago, the learned trial judge dismissed an application was filed by me.
You're not answering.
Yes, my lord, commissioner is appointed. I'm not saying no.
Where is that? So,
My lords,
My lord.
please have page number 108 at
108 it
Annexure
is there.
G.
108.
108 of my complaint.
So that's all. What war is required?
There is nothing wrong, my lord.
If I may, after the appointment of commissioner, why I was forced to file this petition is after the commissioner asked the defendant to give the details of the account so that he can review and do the commissioned work, the defendant does not cooperate with the commissioner. Instead,
That is not our lookout.
My lord,
That is not our lookout.
Milord, there is deliberately the defendant is not cooperating with the commissioner, Milords. Milords, please have the, please see page number 127, Milords. There is an interim report also filed by the commissioner.
So what breach is committed?
My lords, at page number 127, the commissioner himself files an interim report stating that the defendant is not supporting the accused. Defendant is not going along with the commissioner to give details of the account to do the commissioned work.
Page?
Page 127, my lords. Point number 3, my lords. I requested the defendant, Mr. So-and-so, on 19 September 2023, 127 minutes, 127.
Yes.
The third point, my lords. Current status, the third point. I requested the defendant on 19 September 23 to share the root or administrator credentials to the above AWS account. He refused to share it over email. The counsel for the defendant verbally said that he was not sure if anything would be accessible, even if the credentials were shared. All along, my lord, right from the day the interim order was passed, it's the stand of the defendant that he will not comply. In fact, in one of the applications, the defendant says, I shall not comply, I shall not give the source code and put the website up. The order is very clear, my lord, that interim order as prayed for by the plaintiff.
Lord, I have to clarify here before we go further. My lord,
And then if I may complete this line of argument.
My lord, I would like to just clarify this point where my learned friend has made. My lord, at page 132, it is an email communication between the commissioner and the accused. My lord, by then the AWS had suspended account and we did not have access to the account until we paid the invoices. Since then, we have paid it. That's what we say. AWS has suspended, page number 132, my lord. Hi, Sridhar. AWS has suspended the account and do not have access to any of the resources in the account. We have already filed A number 15 to transfer. That's one part. My lord, just above that, he says, Avnish, please share root administrator credentials of the account along with the account IDs. Avnish, my lord, here, root account ID of my AWS account also has data belonging to other customers. I cannot give access to other people's, other customers' confidential data. I said, we cannot give it to you. I cannot share. I mean, not in page 131, I say this. I cannot share root credentials of the account. If you want, we can meet in person and I can show you the state of the account by logging in. So you can please brief us about the procedure that has to be followed for this commission. I have tried to cooperate, but what they're doing is they're sitting remotely and wanting me to share, bear all my confidential data amounting to, that will lead to a lot of problems for me, my lord. Not very important, my lord. From day one, before the suit was filed, I've always claimed that I am the owner of the source code, whereas the complainant is the owner of the website. I have stated very clearly. Now, one other thing, my lord, page, in the orders passed by the.
How can we implement this? In what way we can implement it? As a contempt court?
My lord, the order is not implemented, my lord. As on this date, I don't have a business running.
If they make it difficult for me, how can I comply with the order, my lord?
14th.
14th, much of it. May not have it after 17 because 16, the matter is there for trial court. We've sought for some clarification. So by then, if the trial court can clarify the certain aspects of the order, it will benefit this honorable court's decision making.
So,
And after 17th, any day,
19th.
much of it.
Number 26. Chandranath Ariga case.
Complaining. Compliance with the office objection, kindly grant me a week's time, my lord, for compliance.
2nd December,
Please.
as requested by law.
Number 27.
My lord, I appear for the government. My lord, could I seek for a week's accommodation in this matter? I have to produce the original notification, my lord.
All
This is on the third occasion, my lords. A notification issued by the
2nd December.
Maharaja.
2nd December.
Obliged.
Number 28.
Please, my lord.
HR Shuri.
For the impleading applicant. Lordship, a short accommodation.
Lords, this matter, Lord, Lordships have heard this matter previously, my lords, that the Kalyani, my lords, which is situated, which, my lords, now being are reserved for a graveyard, my lord, that matter, my lords. Was informed, my lords, Mr. DLN Rao, who is appearing for the contesting respondent, my lords, is admitted to hospital. He has requested for a short accommodation, my lord. Short accommodation, maybe any date after 26th of November, my lords, would be convenient to us also. And we are ready for, my lords, I'm not, but since they have made a submission,
29th now.
much, please.
Obliged.
This is number 29.
I am for
Non-filing of complaints in contempt matters.
complaint.
Yes.
This is the direction of the learned single judge, that is internal page number 18, your lordship. The third respondent, who is in accused number 1 before this honorable court, has to register the association under the Apartment Ownership Act 1972. That is, they have not registered, your lordship.
What is the,
We had already filed, your lordship, on 16/7. We have filed the registered deed of declaration in page number 7. Along with the one IA we have filed, there is small rectification, your lordship, in that
so you're supposed to cancel the registration.
That has been done, my
it
lord.
already been registered in 2023 itself. So I had submitted the deed of declaration along with the complaints, whatever we
Lordship,
have done under section
Deed of
11.
declaration, it is not sufficient under the law. After registering deed of declaration, they have to register before the concerned authority, that is Register Cooperative Society.
So
Because of this apartment is having commercial establishment. Therefore, they have to register before the concerned authority after making the deed of declaration. Apart from that, deed of declaration is also having forged document. I have taken some
There is
penal
no
action,
question.
that is PCR is pending before the concerned court. They have not obtained the GPA from the resident of the.
Page number 91, your lordship. The documents which we have submitted before the cooperative societies registrar. So this act says that. Page number 91. your lordship. There are two procedures actually the act has mentioned. One is under section 13 of the Karnataka Apartment Ownership Act.
it says that you have to register a deed of declaration before the jurisdictional sub-registrar. That we have done, that document we have attached. And section 11 says that these document has to be submitted before the cooperative society's registrar. That is also complied, Your Lordship. There were case laws in CRP 96, Your Lordship. Already this court has already mentioned that what are the procedures to be followed. May I submit this document, Your Lordship? CRP 96.
Your Lordship, in the same judgment,
We have complied whatever the statute.
it is a
mentioned.
commercial. It is a commercial establishment. It has to be registered under the Karnataka Flat Ownership Act.
20%. 20% will take.
21st. No.
One, two, nine, six. This is with number serial. Some correction is required.
Yes, Your Lordship, I
They
have
have filed-
submitted on 16/7. After that, on 24th, they filed this application by mentioning that it is not
What
compliant.
happened in initially, this contempt petition was disposed by taking the submission of the learned counsel. On that point of time, they have not registered mine.
Your Lordship, we have.
That is on
registered.
order of 13/6/2024.
We have registered on 2023, Your Lordship. 9/3/2023. And the procedures completely we have followed.
Along with.
And Your Lordship has also mentioned how to follow the procedures. What are the procedures? Page number.
Along
Your
with my
Lordship.
recall IA, I have filed the endorsement which is issued by the competent authority. That is internal page number 7, wherein clearly state that
Will take
this
about-
is not registered.
No urgent.
Date mine.
IA number 1 may be considered, Your Lordship. That correct?
Seal number 30, to Pawan Chandra Shetty.
Certificate for complaint, my lord. My lord, running page number 21, my lord, the writ petition, single judge order, my lord.
My lord, there are certain developments, my lord, we'll file the counter affidavit in this matter, my lord. The paragraph 8 is the direction, my lord. The direction is that 136 proceedings need to be completed, thereafter timeline.
21st, next.
Much obliged, my lord.
Seal number 30. Seal number 31 urgent, seal number 32, to GR Mohan.
But we have complied with the direction. Lord, the facts are that, my lord, the contempt petitioner has shot a movie called May 18, which was originally shot in Tamil. He made a dubbed movie in Kannada. So he has to make an application for certification. He made an application. In the application form, we have a specific question, whether it is dubbed or it is original. He claimed it to be original. Then we said, no, in the lip sync is not matching. The dialogue delivery is not matching with the lip movement. Eventually, he filed a writ petition. In the writ petition, the learned single judge directed us to pass an order. We have now approved the certificate as a dubbed movie. Now, he seems to be agreed with that. He wants it as an original category. Lord, we have taken a decision. So we have complied with the order. If he is agreed with that decision, my lord, that gives rise to a separate cause of action. We have already approved the certificate under the dubbed category.
Kindly see page 16, your lord. It is not, it's a page 16, annexure C, your lord. The certificate it has been approved.
Page.
Page 16, your lord. Annexure C.
16.
16.
is after examination by the committee, with reference to your application to the Central Board of Film Certificate dated 12/11/2023 for certification under the Cinematography Act Toronto to exhibit the film titled May 18, Kannada, your lordship. The word is Kannada. It never says, I am directed by the board to inform you that the film has been reviewed by the examination committee and the board has come to the conclusion that the film is not suitable for unrestricted public exhibition, but may be suitable for public exhibition restricted to adults only, provided you carry out the excision or modification in the film listed in the annexure, and that you should accordingly be requested to carry out the excision modification.
This is the old one, 2023,
So
old.
up to that, I submitted my cuts and excision. So they are not considered that in spite of that, then this film was to be, I'm not screening it any theatre. So only for the purpose of award it has been. Then since it was not considered in spite of my representation, the annexure, your lordship may kindly see the court passed on our annexure F, your lordship, page 25.
No, but this is not the order which is said to be disobeyed. This is an earlier order.
And page 27, para 3, very clearly this honorable court has observed. Para 3, your lordship, page 27. May I read para 3, your lordship. In addition to reading the various, we are reading.
So what is the breach?
I am not screening this because only for film festival I submitted my film. And also my application is also original language Kannada, your lordship. Only to overcome these all orders of this court, they are saying now it is a dubbed film. That is not, and kindly see, now after filing the writ petition, your lordship may kindly see.
Which are the directions to be compliant with?
Page 48.
Page 48.
Page
and
30, your lordship, page 30, annex H, your lordship.
Page 48 are the directions.
Yes, your lordship, 48.
So which direction is breached?
They have to consider it, they have not done it. They have not done it till today.
They have not?
They have not done it. Even I sent my email also, no reply. That is why kindly see para 3, the respondents are permitted to pass a fresh order on the
But you
request
are
of the
not
petitioner for certification. If
we
any
have-
order is passed,
We have,
it can be. They have not passed any order. This is the
this-
email I sent.
for this, we have an interactive website, user friendly. So we don't do physical correspondence. So we have already uploaded this certificate. The approved certificate is already uploaded. He has to upload the movie and then collect a physical certificate. So we have already approved. We have already approved the.
File because that is all totally false. Because
No,
the
lordship may
annex
record
H,
my submission.
they
We have
withdrawn the
taken a decision. We have complied with the order.
Annex H, kindly see, page 30, your lordship. That has been withdrawn when the writ petition, page 3030 for a moment, your lordship. He says it's a dubbed movie, page 30, your lordship.
So
30.
fresh order is uploaded.
They
Yes.
given a,
We have
this
already-
endorsement was challenged.
The
They-
approval of the certificate
They
is
withdrew
already.
this endorsement. Annex H.
Certificate has been approved.
Dual order of
Annex
certificate.
A, it was as per, it was A certificate was granted, I accepted it, I am not disputing that. Now they are saying that it's a dubbed after, kindly,
Are we in mobile conference?
pardon?
Are we talking in mobile conference? So why you are go on talking when I am asking the council?
Well, Annex H, kindly see your lordship.
27th.
Let them file affidavit.
There is no contempt, Mr. Council.
I'm good.
You go on talking instead of solving the matter. Go on submitting, go on submitting,
No,
go on
that's why I'm reading, they withdrew the Annex H, your lordship. Annex H, I challenge, they withdrew it. That means the original application stands, that's my response submission. They withdrew that Annex H. They are not saying why they have withdrew it. That is the,
We'll consider
that is the difficulty.
on 27th.
Please.
Ready notice matters, number 33.
My lord,
Channamalli
I appear for the respondents. I pray for some time to file my objections, my lord.
When you will file?
My lord, 4 weeks, my lord. Interim order is granted, my lord.
2nd December. Interim orders will continue to operate.
Till
Till the next.
Number 34.
34,
State
government,
appeal.
government appeal, my lord.
For respondent number
Delay.
1 to 4.
Delay notice.
Delay up to
returnable.
15 days.
My lord, so far a delay is concerned, my lord, I have no objection. Except para 3, your lordship may kindly see.
But who is for the petition?
I'm government appeal, my lord. There's a
Who is
delay
for
of
your appeal?
215 days delay is there, my lord. Lordship may kindly condone the delay and post it for hearing next week, my lord.
Learned, additional government advocate. Sir Harish. The You represent all the respondents?
1 to 4, my lord, I appear for. 1 to 4. Respondent number 1 to 4.
Then notice has to go, notice.
No,
written
notice
number
has been
also.
ordered, my lord.
It
Others
has
are
been
served
already
and
ordered.
unrepresented. Served and
They have been
unrepresented.
served already. They have been served, my lord.
They have been served.
Served and unrepresented before your lordship.
Or learned additional law entered. Mr. Harish Purthy. Appellant applicant. Our learned advocate, Mr. Learned senior advocate.
Yes, so far as continuation of delay is concerned, your
Correspond
lordship may
1 to
kindly
4.
see para 3.
And learned senior advocate, but number 1 to 4. This one number 4 and 5 are served with the notice of this court, however, none has appeared on their behalf. This application is filed by the appellant state, seeking to, praying to condone the delay of 215 days, which has occurred in preparing the writ appeal. The accompanying affidavit, the affidavit accompanying the application explains the passage of time to state that after the judgment was delivered by learned single judge, the copy was obtained, certified copy was obtained. Also, the Office of Advocate General forwarded the certified copy with his opinion to the legal cell.
My lord, may I request your para 3, your lordship may kindly. Para 3.
No, Advocate General refused to file for this.
Yes, my lord, according to them, according to the office of the advocate general, it is not a fit case to file appeal.
My lord, thereafter addition has been taken, taking into consideration the financial implications, my lord. The addition has been taken, a government order has been passed on January 2024
Forwarded by the Advocate
for
General.
preference of appeal.
Opinion was forwarded by the Advocate General, stating that it was that the case was not fit to prefer the appeal. However, subsequently, the matter was considered at the different hierarchy of the, at the hierarchy of, at the different levels of the,
Yes.
at the different governmental levels in the hierarchy of authorities. Full stop. The Secretary, Department of School Education considered the matter and the financial implications were noticed. Therefore, finally, the government passed order dated 28/2/24, authorizing the government advocate to file the appeal. Post of the passage of time leading to paragraph 215 days delay is due to above procedure. It could not be said that there is an element of culpability in whiling away the time. The administrative process leading to decision to file the appeal consumed the time. Sufficient cause is made out, delay is condoned. Application is allowed. Appeal may be listed 4th of November, 4th of December.
Grateful.
Great.
Number 35, Shailesh.
Here for the appellate in this matter.
Here for respondent 2, my lord.
35.
Respondent 1, Your Honor. Lord, respondent 1 is my husband.
Yes, why the client is here? Why is client is standing here?
Sir, I am PAP. I have forwarded my application for
Why the party in person speaking? He is not permitted to address unless we call up.
No, my lord. I am for
As
respondent.
certificate. Please ask your client not to speak a word.
I am for respondent too, my lord. Respondent one. I am for the bank.
This is not the way. Is your client?
No, my lord. I
Then
am
who
for
is
the
he?
respondent too, my lord. Bank.
He is not supposed to speak. This is the court of the lawyers, not the party in persons, unless they are certified to be competent to address the court. He is a party to the proceedings?
He is a party to the proceedings.
Maybe. Yes,
The-
what is the matter?
My lord, my matter is this, my lord, very simple. The first respondent who was there before this honorable court, he is my husband, against whom divorce proceedings are going on. my lord. I have got half right over the property, and he has taken a loan which he has failed to repay to the bank. I have come forward to pay the entire loan amount. The only thing which I mentioned was that he hand over the documents to me, I'll redeem the mortgage, hand over the entire documents to me, is what I filed an affidavit before this honorable court, before the learned single judge. The learned single judge has not considered only that part of it. Therefore, the bank is refusing to accept the redemption of mortgage in my favor. Because if I am willing to pay the entire loan. That's what I have also mentioned in the affidavit.
So what makes you to file the appeal?
I have filed an affidavit before the learned single judge
Correct.
saying that I am undertaking to repay the entire loan.
And in that term it is
And
disposed.
I also made a mention, I will redeem the mortgage. Please hand over the documents to me. What the bank is saying is, I cannot do so unless there is a specific order from the court, which was absent before the learned single judge. That's the only contention. If they are willing to give me the documents of title and accept my title, I am willing to repay the entire loan due to the bank.
So both has to be simultaneous.
My lord?
Your payment, repayment,
Yeah.
and the return of document may be simultaneous.
Simultaneous. But she has sent
After you
file.
re-
I'm not a borrower. my lord.
After you repay in 3 installments, the documents will be returned.
Yes,
No,
my
no.
lord.
If they say, if it is not found, because when the
She has
Well,
undertaken, my lord. She has undertaken that she'll file, she'll clear
You are
within
for the bank,
bank, my lord.
so you return, why you are not giving back?
That's what, my lord, she has not filed, she has not even filed one installment, my lord. The bank loan account, not
Not a
paid, my lord.
single installment?
No, madam. This is the statement,
I-
my lord.
Why I'm not, because when I went to the bank and asked the bank to give me the documents, to give a letter or at least saying that we'll give the documents back to you, they have refused, saying that there is no specific order from the court. Therefore, I'm now making a mention, a submission before this honorable court, we'll repay the entire loan.
Why you are fighting? If you are ready
Let-
to,
Let,
as a bank, you are ready to give back the documents once the entire amount is paid.
yes, my lord, but both the parties.
If that
to
is
be-
recorded, my lord, I'm okay. my lord.
Both the parties to be present because the property belongs to both also, my lord. But she has undertaken,
But he is paying the amount.
yes, no, my lord, both also not paying, even respondent one also not paying. them.
After the entire amount is paid, you will be returning the documents.
My lord, I'll take instructions, my lord. A date may be.
Your husband and wife,
Yes, my lord.
Husband and wife, my lord.
and you are at dispute.
I have a dispute, divorce proceedings are going on. He has remarried again. He has got a child of his own. But I am undertaking because I have got 2 daughters. my lord.
Property is with whom?
Property belongs to each of half property to
Both-
me and half property to
Both,
him.
my lord.
I am not a
Husband and
loanee
wife.
also. I am not a borrower also. But still I am willing to pay the entire loan due to the bank.
If the bank were to say, we will give you the documents on the repayment of the loan, I would bow down and we will take them.
You both receive the document jointly.
Not the issue would be because there are proceedings are going on for divorce proceedings. I'm not a borrower. My relatives have come forward to pay the money on my behalf. I'm willing to redeem the mortgage in my favor. If the bank says, I will hand over the documents and discharge the mortgage in my favor, I'm willing to pay the entire loan amount. Bank will also not have any dispute.
But that question is really not arising on the appeal.
Yes.
The question is really not arising in this appeal.
No, the only issue is if they were to say, if they were to make a mention.
That aspect doesn't arise in this appeal. Why should we go in the appeal in that question? Nothing is stated.
No, only thing is.
About document, anything stated in the order?
Nothing.
No, what I have mentioned, I filed an affidavit before the learned single judge. In that affidavit, I may clearly mentioned the original documents have to be handed over to me. So that when I take when I have the title over the property, I'll repay the entire loan. That's the only submission. And in fact, that is found in the mention.
Then go before learned single judge and get it clarified. Go before learned single judge and get the things clarified. Here that question does not arise in appeal. What is to be exercised in appeal? What powers to be exercised? That aspect doesn't arise. There is no cause for you to appeal against this order.
Yes,
What is
it has not
submitted
been
by
clear.
you is not part of the order, either directly or indirectly. How can you invoke the jurisdiction of the appellate jurisdiction for the such submission when it is not forming anywhere? If
I
you are-
understand, my lord. I understand what your lordship is
Then
saying.
you can go.
Only one submission which may be permitted to make is this, my lord. If the documents are given to me, of course, I can go back to the learned single judge and make a mention of this particular fact. But the reason I mentioned was, even though affidavit was filed before the learned single judge, that was not culled out in the order. That's the reason I am before this honor.
We do not know why learned single is not taken care of that. We are disposing of permitting you to go before learned.
My lord,
If you want to find out some way out with the bank, we can adjourn it.
Please, my lord,
But there
your
is no-
lordship may do one thing.
There is no cause for us to exercise the appellate
I
jurisdiction.
understand, my lord. They make one submission, my lord. I will also talk to my client and make a submission. Your lordship may have it on Tuesday, not even 3 days, my lord. In the meanwhile, they have issued a notice for 8 days, 8 days notice to take physical possession. Till Tuesday, let them not take possession. That's the only thing. Till Tuesday. I'm not even asking for more. Because they have issued saying that I'm going to take physical possession of the property. They have they have issued a notice which is there.
Yes, what do you say?
My lord, I'll take the instruction and let the
As both the councils
notice may be.
or the parties have opted to request the court to keep the appeal to be taken up on 20th November 2024. The appeal shall stand out to 24th. Learned advocate, Mr. So-and-so, Respondent Bank. Shall we record your statement?
Nagaraj. My lord?
Shall we record your statement
Yes, ma'am.
that no coercive steps will be in your
Copy.
dependency of this appeal?
I'll submit them. I'll talk to my client.
But there is nothing in your appeal.
No, I understand, my lord.
So please get dates today. No.
Obliged.
Lords, may I request, Lords, that matter which your lordship passed over, would it be on a short date next week?
21st. 21st.
My lord, 21st, my lord, 20th or 22nd, my lord.
22nd.
The
Obliged.
difficulty, Lords, could it be next week? The difficulty is this, Lords. They
Next-
enforce that demand in the meanwhile.
20.
Lords, 14, Lords, Lords, that every quarter they ask me to pay 8 crores, Lords, that's my difficulty. And it's a covered matter. Kindly consider for
22nd.
the fourth.
Obliged, my lord.
My lord, may I have my lord's kind leave to mention item number 88. It's a contempt petition under extremely urgent circumstances. We have moved the court. Can it be taken up next week, subject to the court's
What is the
convenience?
urgency?
My lord,
What is the urgency?
the urgency is there's some demolition work which is happening, which is why the business is completely stalled, my lord.
Demolition is going on.
Yes, yes. By the landlord. Can it be taken up on Monday, my lord?
13th.
Next week?
13th next week.
Wait,
My lord, item number 61, my lord, contempt matter, my lord. The petitioner is the practicing advocate, my lord. He is a tenant. The respondent is the bank, my lord. He was thrown out with the tenant house, my lord. The bank also they sell the property, my lord. Excess amount laid in the bank, my lord. Therefore, my lord,
25th.
please.
39, my lords, 39, my lords. Kindly, my lords, 39. Lordships may kindly have it next week. One round of contempt has been filed where they say that the land was utilized without acquisition.
25th.
20.
I'm so grateful.